Hello, everyone. Justin Stivers here, managing partner of Stivers Wealth Management and former estate planning attorney. Talking today about wills, so last will and testaments versus beneficiary designation. Which one wins? So, one of the most common misunderstandings that I came across during my little over decade of practicing estate planning law was this: people thought that their last will and testament, controlled everything. And I'll use kind of will and trust somewhat interchangeably, but they are very different. But a lot of people just thought, hey, whatever I have in my will, that's actually what's going to happen. They would spend all this time, this money creating the will or trust, just kind of feeling confident that everything was in order. And then years later, they would discover that certain assets weren't going to go where they intended at all. And the reason was beneficiary designations. And so what I'm going to, explain in this video is the difference between a will and beneficiary designation, which one takes priority, and really why you should be reviewing your beneficiary designations pretty somewhat frequently, because it might be one of the most important estate planning tasks that you complete. And so common assumptions that a lot of people make. So imagine your will says, I want to divide everything equally among my three children, right? Seems pretty straightforward. But if your IRA or your 401k lists only one child as a beneficiary, or your life insurance policy still names an ex-spouse, or maybe if you have an annuity, it names your quote unquote estate instead of your trust. In a lot of those cases, those beneficiary designations are going to control where those assets go and not your will. And that's where your problems begin. And really, again, kind of backing up, a beneficiary designation is filling out typically a form with the institution where you have that asset, right? So, as simple as a checking account at whatever bank you use, a lot of times when you're filling out that application, they're going to ask you, who do you want to name as your beneficiary? Or when you're filling out, an application to open up a brokerage account, an investment account, they're going to say, who do you want to put as your beneficiary? A lot of times people don't even put them, which is a whole issue, right? But a lot of people don't realize how many assets they have are going to pass by beneficiary designation. So again, this could be an IRA, a Roth IRA, a 401k, a 403b, life insurance policies, annuities, investment accounts, brokerage accounts, payable on death accounts, right? Or transferable on death accounts, like your checking, your savings accounts. Those assets, the good thing is they're generally going to bypass probate, which, as both a estate planning attorney and as a financial planner, I almost always, can't think of a reason I wouldn't, but most of the time, I'm going to very strongly suggest my clients avoid probate. And by listing beneficiary designations, by listing someone as a beneficiary on the form itself, you're going to avoid probate, bypass probate, and that's a huge advantage. But it also means that those beneficiary forms can carry a tremendous amount of weight. So, which one wins, the beneficiary form, or if you've got a will or a trust? Right? In most cases, and I can't say all, but in most cases, the beneficiary designation form wins, right? I'll say that again. If you've listed a spouse, child, or somebody as a beneficiary on that specific account, that specific asset, that's who's going to get that thing, even if your will says otherwise. Your will says, again, I want my three children to get everything equally. Well, if you list one of your kids as a beneficiary on one of those accounts, he or she is going to get that account 100%. The other two are going to be left out of that. And that surprises a lot of people, right? I've had a lot of conversations with families who are absolutely convinced, mom or dad's will, that controls everything. But the financial institution doesn't look at the will, right? They're not going to, you can't bring in a will to, Fidelity, Vanguard, choose pick your institution of choice. They're not going to look at that until probate happens, right? And you've been named as the personal representative. But if you've already got a beneficiary designation on file with them, that's all they're going to care about, right? They're going to look at their form irrespective of what the will says, and that's typically where the money is going to go. And so I saw a lot of mistakes repeatedly over the years. And the first was just simply failing to update beneficiaries after a major life event, right? After a person gets married, after a person gets divorced, the birth of a child, the death of a spouse, the death of a beneficiary. People will often, I won't say always, but a lot of times at some point they will update their will, maybe once, maybe twice in their lifetime, but they forget to actually update the paperwork that they have on file with the bank, right? The second mistake I would see is they would name the estate as the beneficiary. I don't really know where this information comes from. I see it and I hear it even now. A lot of people say it, hey, let's just name your estate. The problem with that is it just doesn't really make sense. A lot of the times it can't, I mean, maybe there's a good reason out there. But most of the time, again, in each law, each state is different. So there may be reasons. So again, this is not legal advice and your situation is going to be unique. But most of the time that just means you're going to probate, and that's going to create additional complexity, right? So a lot of times I don't see the real benefit of that. The third mistake I saw or still see is naming a minor child. Most or a lot of parents assume they can just name their child directly as a beneficiary. And often it's not usually that simple. I mean, I think intuitively we know, you can't just leave $100,000, whatever the amount is, to a 5-year-old, right? And so in most of those situations, there's going to have to be what's called a guardianship or a conservator that's going to be appointed to kind of manage and oversee those funds until the minor becomes 18 or becomes an adult, right? So that's an issue. And the fourth was just failing to coordinate beneficiary designations with trust. I see this all the time. My estate planning practice, we almost always did trust for the majority of our clients. And we were very, very, let's say, pushy about making sure that the trusts were named, and again, depends on the asset. So this is asset specific, but let's just say broadly speaking, we wanted to have the trust either be the account owner of the asset or the beneficiary. And I just would see time and time again, people would, get these beautiful estate plans, these beautiful trusts, and they would never list the asset. They would never put the asset into the trust. And ultimately what happened is the trust didn't function as they intended. And so now those assets would go either directly to the beneficiary or maybe to probate, right? That's a big issue I would see. Another area people would overlook is taxes, right? Not all inherited assets are treated the same. For example, a taxable brokerage account, like a traditional investment account, may and likely will receive a step up in basis. A traditional IRA generally does not. Traditional retirement accounts are often going to be taxable to beneficiaries as the distributions are received, whereas Roth IRAs are going to receive a different tax treatment. Doesn't necessarily mean one beneficiary should receive one asset and another beneficiary should receive a different asset, because again, the tax treatment is the same. And so it does require some thoughtful planning when you're determining who gets what, because two beneficiaries inheriting accounts with the same dollar amounts, if they're different types of accounts, one's a Roth, one's not a Roth, doesn't mean that they're going to get the same after-tax benefit. So there does have to be some planning when you're just deciding who's going to get what account, who you're going to list as the beneficiary. So the good news is that reviewing your beneficiaries really doesn't have to be that complicated. Start just by making a list of all of your accounts, your retirement accounts, your investment accounts, life insurance policies, annuities, bank accounts, CDs, whatever it is. then ask yourself and go look, right? Go look. Don't just uh, think, oh yeah, I named that person, because I can't tell you how many times I've seen where nobody was named, right? It could have been the bank messed up and just didn't put anybody on there. Could be the beneficiary died. It could be that it's your ex-spouse who you probably don't want to get the money, right? But look, who's the primary beneficiary? Who's the contingent beneficiary or the secondary beneficiary? Are those the right people? Do you still want those people to be beneficiaries? Do those beneficiaries align with your current estate plan? If you have a will, if you have a trust, does it say something different? Have any beneficiaries, again, died? Has there been any major changes in your life since you last reviewed them? If you haven't looked at the beneficiaries and your accounts in a couple of years, it's probably a good time to revisit. I don't have a hard and fast rule of when people should do this, but I would say every 2, every 3 years, it's worth just a look, right? Just to make sure, look at all your accounts and just double, triple check, because I'll tell you, it happens all the time. Something happens and the beneficiary wasn't named, or it's not the proper person. So biggest takeaway is just estate planning. It's not just about the documents. You got to make sure all the pieces work together. Again, when I came to this side of the table from an estate attorney to a financial planning, that was one of the reasons I wanted to do it, because I just felt like the estate planning side was all about drafting documents, and it gave people really a false sense of, hey, this is done. I don't have to think about it again. Whereas on this side of the table, I get to help people coordinate. And because I have that kind of background as both, I'm very I'm very involved in making sure all the pieces kind of line up. Your will, your trust, your beneficiary designations, your retirement accounts, insurance policies, all of that. And when those pieces are coordinated, it's much more likely that whatever your wishes are when they were written down, they're actually going to be carried out the way you intend. So when you don't do that, you're going to have unintended consequences, and those consequences can be very costly, very painful for all people involved. So again, if it's been a little while since you've looked at the beneficiary designations, consider taking a fresh look. I know this is not a very exciting topic necessarily, and it's something that I think a lot of people put off or just don't do it, but it can really, really be one of the most important things you can do as part of your, kind of overall estate planning process. So good luck out there. We're always here to help if we can. Thank you all.